Hi, everyone. Thank you so much for joining us. My name is Sarah. I'm the development manager with CPAWS British Columbia, and I'm going to get us going here. It is 6 o'clock, so we will get going. If you have any questions, you can send a message to me in the chat. I'll be keeping an eye on that. You can also see there's an email address on your screen, info@cpawsbc.org. Somebody from our staff team can answer your questions and provide any technical support if you need it, if you send a quick email. So as I mentioned, my name is Sarah McNeil. I'm the development manager for CPAWS British Columbia, and I use the pronouns she and her. I'm so glad that you're all able to join us tonight, and of course, really grateful to Mike of Westcoast Wills Estates for joining us and sharing his expertise. I do want to get going quickly because I know Mike has a lot to share, and you're all here to learn from him. So just a few quick things before we start. If you would like to rename yourself, you can do that by using the participants tab on your Zoom link. So at the top or bottom of your Zoom, you should have a little participants window, and that should let you click on the little dots beside your name and choose to rename yourself with your first name, last name. You could add your pronouns if you are able and would like to share those. That can be really useful for everyone else when we get to answering questions. I'm going to keep everyone muted through the webinar just so that we can all hear our speaker clearly. That's the most important thing, but we will be checking the chat. So if you have questions throughout the presentation that you want to remember, or you want to ask Mike at the end of the presentation during questions and answers, you can drop your questions right in the chat. We will give people a chance for those questions towards the end of the presentation. You can turn your video on and off using the camera icon. Usually it's at the bottom left of your screen, but it could be at the top, depending on where your Zoom control panel is. I encourage you to leave your camera off if you can, at least through Mike's presentation. It does usually help with internet issues or glitches and help the presentation run a little bit more smoothly. So welcome to leave your camera off if you're able to do that. We're going to drop a link in the chat. My colleague Sky just dropped a chat message in about the questions, and also she's going to drop a link in for a live transcript of the presentation. So if you need transcript or you're having trouble with the audio, there will be a link in the chat and you can click on that. It will open a new browser window and it will be a live transcript of whatever you're hearing in the webinar. It's not a perfect transcript because it is through AI, artificial intelligence listening, but it will help clarify some of the sound if you're having trouble listening. So Sky, if you can drop the Otter AI link into the chat when you get a chance, that would be great. And of course, if you have any questions or if you need assistance, you can use the chat function and someone from the CPAWS team will reach out to you and answer your questions. So hopefully that will cover most of our technical issues, but of course, we're happy to support as we go. For those who have answered, yes, we are recording this webinar, and we will try to share it. If technology is on our side, I make no promises because we're somewhat new still to this webinar system, but we will do our very best to have a recording available for folks after the webinar as well. And then finally, before we get started, I just want to acknowledge that the CPAWS British Columbia offices are located on the unceded and stolen territories of the Tsleil-Waututh, Squamish, and Musqueam nations on Coast Salish territory. CPAWS-BC also works on the unceded and stolen lands and waters of 198 First Nations located all across the province of British Columbia. Personally, I'm speaking to you today from Secwepemcúlecw, the unceded and stolen lands of the Secwepemc Nation in what is now Kamloops, British Columbia. So we'd like to take a moment to acknowledge the first stewards and still stewards of the land where we all live and work when we have the privilege of joining together like this. And I know that there are people joining from all across the province and indeed across the country from the territories of many nations here in Canada. So thank you all for joining us. Quickly, I think many of you know me or have seen my face in your inbox, and you have supported CPAWS for many years, and thank you. For those of you who are new to CPAWS and our team here and what we do, CPAWS is working to protect lands and waters across the province, particularly focusing on large level landscape or ecosystem protection. We're in crisis right now as a society, fighting the side-by-side climate and biodiversity crises, and it is possible to push back and to start make some progress on that. And that's the work that CPAWS is focusing on: protecting habitat for endangered species, ensuring that communities that rely on natural ecosystems and the natural world are still able to do so, and ensuring the well-being of all of us by protecting nature. So if you have any questions about CPAWS and the work that we do, again, you can drop them in the chat or send me an email. You'll all have had a handful of emails from me over the last few weeks, and I would be happy to speak with you about any of those issues. And without further ado, I'm going to turn things over to Mike. Mike was born and raised in North Vancouver. He's a graduate of both the UBC and Dalhousie, both UBC and the Dalhousie Law School in Halifax, and he founded Westcoast Wills and Estates out of his longtime passion for wills and estate planning. He has extensive experience in estate planning, preparing wills, trusts, representation agreements, and power of attorney, and I know he has a lot to teach us all. So without further ado, Mike, I will turn things over to you. Thank you so much for being with us tonight.
Thanks, Sarah. Thank you, CPAWS, for having me. So I'll just try to share my screen here. That's what we were trying to do before, so hopefully that works. Okay. So yeah, I'm Mike from Westcoast Wills and Estates, and this session will be about estate planning. So what is estate planning? This is too often people say, what is an estate plan anyway? I just want a will. Often my clients say that. So who here has an estate plan? And I understand that there's some function to take a poll of the audience. Ooh, the poll pops up for me as well. I have an estate plan. Yes, it's up to date. Oh, estate, okay, yeah. Okay, yeah.
Mike, I don't know if you can see the responses. I don't think you can. They're just coming in now. It looks like we're almost split equally between yes and it's up to date, yes and it needs to be updated, and no. So we have a pretty close split between all three of those options. Give people a few more seconds. There's a few people who haven't voted yet if you'd like to vote. And so we're at 36% yes and it's up to date, 24% yes and it needs to be updated, and 36% are say no, they do not have a will.
Shocking, shocking. Okay, so we'll start at the general estate plan level. So what is estate planning? Oh. Oh, there we are. What is estate planning? It's providing for loved ones in the most cost-effective, quickest, and dispute-free way. We also lump in incapacity planning with estate planning just because it's convenient to do so, because you only want to think about death and incapacity and meet with a lawyer one time, not two times. So incapacity planning is basically asking the question, what happens with my finances and my healthcare if I'm So estate planning is sort of the umbrella term for looking at a number of things, only one of which is a will. It's essential to look at all of these things for a complete estate plan. So included in these things is life insurance. Do you have it? How much is it? Do you have enough? And who's the beneficiary? Beneficiary designations on other accounts. So we look at who's the beneficiary on your RSP, on your RIF, on your pension plan, on your tax-free savings account. Joint ownership, we look at who's a joint owner of your investment account, your bank account, your real estate. And then we look at wills, of course. Trusts can be held within a will or outside of a will. So if it's outside of a will, we look at whether that's appropriate for your estate plan and what you're trying to achieve. And then there's giving during your lifetime. That's always an option. And then, of course, there's the incapacity planning documents, which I talked about before. It's power of attorney, let someone else make financial decisions for you. And there's healthcare documents, which make give the other people the ability to make healthcare decisions for you. So why estate planning? Instead of just jumping to the will, why estate planning? Well, if you jump to the will, oftentimes you skip some steps and things aren't as smooth as you would wish when you die. So it simplifies things for loved ones, it minimizes disputes, it minimizes costs and taxes, and it avoids sometimes probate. And we'll get to that P word a little later in the presentation. So to the basics now, there's 3 ways your assets can pass when you die, only 3 ways. And we'll go over each of them. If you have a beneficiary listed on that asset, so this is life insurance, pension plans, RSPs, RIFs, or a tax-free savings account, they all allow a beneficiary to be listed. If you have a beneficiary listed on any one of those accounts, when you die, they go straight to those beneficiaries. Outside of what you say in your will, it's just straight to those beneficiaries, straight from the financial institution to those beneficiaries. The second way things can pass when you die is through joint tenancy. And usually it's joint tenancy between spouses. And so if one spouse dies and say a home is held in joint tenancy between the 2 spouses, the survivor will just assume the full ownership of the house through that joint tenancy. Again, outside of what the will says, it's just by operation of the law. That's how joint tenancy works. The third way things can pass upon your death is through your estate. And that is what your will deals with. Your will does not deal with the jointly owned accounts or beneficiary designated accounts. So just things that pass through your estate. And that's crucial to realize because a lot of people who skip to doing their own wills or doing an online will or something don't realize that these beneficiary designated assets and these jointly held assets pass outside of the will. So a common mistake is just to give a jointly held asset in your will to someone else, but it's not yours to give because the second you die, it transfers to the survivor. So a little word of caution about joint tenancy. If you're going to remember anything from this presentation, remember this word of caution. Joint tenancy between spouses normally is fine. It just passes to the survivor when one person dies. Joint tenancy between a parent and a child is a whole different situation. And oftentimes the survivor of the 2 spouses, thinks, oh, that was easy. My home transferred directly to me without this probate thing, without any legal help. And that was so easy. So I'll put my own children as joint tenants, or one of my children as joint tenants in my house, and it'll pass directly to them when I die. This is not so. There's a presumption in the law which just says when a parent puts an asset in joint tenancy, whether it be a home or a bank account, in joint tenancy with a child, it's presumed to be just for convenience, and it passes according to the parent's will. So when the parent dies, the child has the obligation to distribute that asset according to the parent's will. So it's called a resulting trust. They have to hold that asset in trust and distribute to the beneficiaries of the will. Obviously, that creates huge problems because some children take the stance that mom loved me more, that's why she put me as joint tenant to the account. And you were away in London and you did nothing for her care for the last 10 years. And so I'm taking this jointly held account. And so it winds up in court every single day in Canada. And so if you're going to take one thing out of this presentation, is consult with legal advice, a proper legal professional, before putting things in joint tenancy with a child. It is a rebuttable presumption, so with the proper legal paperwork, it can be done properly. But just making them joint on the account leads to all sorts of problems. And that's what this says. So a little bit about assets that pass through your estate. They pass according to your will. So this is the third class, not jointly owned, not beneficiary designated, but through your estate. They pass according to your will. If you don't have a will, they just pass to your next of kin according to the default law in BC. If assets are substantial, with or without a will, it doesn't matter, probate will be required. So what is probate? In the legal sense, probate is a court process where a court just stamps a will as being valid, and the executor is the person you should be dealing with. It says to the outside world, to the banks, the land titles office, deal with his executor. This is a valid will. But to get there, it's a whole court application, typically involving lawyers, and it costs maybe $3,000 or $4,000. In the general sense, just out there in the community, people refer to probate as the entire process, which can last in between 1 and 2 years. And that's the reason for the massive delay is because of taxes. And so the court application itself that I was talking about before only takes about 2 to 3 months. The whole process takes 1 to 2 years because if you can imagine, if someone dies in January, you can't file their tax return for that particular year until the next spring. So you have to wait a full year in order to file their tax return. So typically estates take between 1 and 2 years to wrap up. Crucially, there's a probate tax, probate fee, the government calls it, but it's just a plain tax. And it's 1.4% of the total value of the assets passing according to the will. Why people want to avoid probate is to avoid this tax and to avoid dealing with lawyers like me. So half my job is to help people estate plan, half my job is to help executors through probate. And a lot of estate planning lawyers have the same job description. Half is to help do up documents like wills, and half is to help executors. So what is a will? Only 50% of Canadians have one up to date. Apparently only 30-something% of the audience today. So good for you to watch this presentation. And basically it's instructions for what to do with your assets when you die. Relatively inexpensive in the grand scheme of things, gives you peace of mind, and it's a must-have piece of your estate plan. So, choosing your executor. Poll question, who's been an executor before? Even though I've helped hundreds of executors over the years, I've never been an executor myself, and I sort of pity executors because it's a lot of work. It's a part-time job for between 1 and 2 years. Do we have results from that?
We do, yes. Thanks, Mike. With 83% of the audience participating, we have had 35% of attendees who have been an executor, but the majority, 65%, have not.
Well, congratulations, those 30 some odd percent, for getting through it. So the executor's job is basically to carry out the terms of a will. So they do everything from arranging the funeral, arranging for taxes to be paid. If probate's required, they hire a lawyer to file for probate. If a house needs to be sold, they hire a realtor to sell the house. After probate, they gather up all the assets. Out of those assets, they pay all the debts, the taxes, and then finally they pay to the beneficiaries who you name in your will. 1,000 steps in between, of course, but that's just the overview. So choosing your executor is key, because if you choose the wrong one, all sorts of bad things can happen. So, if this slide would advance. Okay, perfect. So good traits for an executor are trustworthy, responsible, local, competent in paying bills, and delegating to professionals, and a bit of spare time on their hands. So notice I didn't mention that they have to be some hoity-toity lawyer or banker or business person or an accountant. In my experience, these people have made some of the worst executors I've dealt with, for the sole reason of they don't have time, a lot of these people, to deal with an estate and their full-time job, which is oftentimes, especially for lawyers and accountants, they often work overtime hours. So to deal with an estate is just an extra burden on them. In my experience, professions like school teachers have been the best executors I've ever dealt with, because by and large, they are all of these ideal traits. They're well educated, they're smart, and they do have a little bit of spare time on their hands as well. So these are obviously ideal executors, traits that you're looking for in an executor. If there's nobody in your personal world that fits these traits, or you don't want to burden anyone personally with this job, part-time job for 1 or 2 years, there is a number of trust companies out there who can take on the burden of executor. The downside is they charge a fee for acting, but the good thing is they do a good job, and they do it efficiently, and the estate gets distributed in a timely manner. And so every major bank has a trust company, and there's also a few independent trust companies out there in Vancouver. So what can wills say? Just generally, wills can give specific gifts of cash, things, or real estate, either to people or to charities. All wills have a residue clause, and that is after the debts have been paid, after all these specific gifts have gone out, what's left gets divided into these certain percentages. And so all wills have to have a residue clause, because you can't possibly account for everything that you own in those specific gift provisions. So you'll always have an old TV that you leave out. So and typically for simple wills with simple families, there are sometimes 1 or 2 cash gifts, maybe to favorite charities, but then the residue just gets divided amongst the children. Wills can also create ongoing trusts. And so beyond that 1 or 2 years, the executor pays out to the trustee to hold that money on the trust terms created in the will. So some of the more common will trusts, just before I get there. So what a trust is basically one person called the trustee holding assets in trust for the benefit of another person, which is called the beneficiary. And typically the trustee has the right to pay out to the beneficiary on terms created in the trust. And so these are typical trusts. There's hundreds of types of trusts out there. They're used in all different industries, but specific to wills, there's probably 10 or 12 sort of more common types of trusts. I've just listed 4 here just to get your minds thinking about what sort of trusts can be used in your will. I didn't list the most common type of trust, which is just a trust for a minor child. Minor children can't inherit directly, cannot inherit directly, so they have to be provided for in a trust. And that trust has to pay out at a minimum age of 19 in BC. And so that's by far the most common type of trust that are in most wills. If there's any possibility of a minor child inheriting under your will, you have to have this default trust that the trustee carries the asset until the child reaches 19. Other types of trusts, family trusts, and these are for sort of wealthier families. So instead of, say, there's 2 children and parents of these 2 children, instead of giving these 2 children an outright inheritance that they will then use to invest and buy their own real estate, the parents create a trust that they give the children. So the children are in charge of their own trust for their entire lifetimes, and they can pay out for either their benefit, their spouse's benefit, or their own children's benefit during their lifetime. And so imagine one of the children is in a high tax bracket and is married to someone who is in a lower tax bracket. Well, paying the income out of the trust to this person, to their spouse, who is in the lower tax bracket, could benefit because they pay less taxes, and it could save tens or hundreds of thousands of dollars over the lifetime of someone. There's trust for disabled people as well. And so if you're planning on providing for someone who's receiving provincial disability assistance, so PWD is called, pay attention because it's important. In order to qualify for PWD, provincial disability assistance, you can have no more than $100,000 in your own name, except for a car or a house. And so beyond that, if you have $120,000 in your own name in an investment account, you get kicked off of disability assistance. And that means much more than just losing the $900 a month check. That could mean, it does mean losing preferred rates on bus passes, discounted prescription drugs. Could even mean kicking you out of the child's house, just because a lot of disabled people live in subsidized housing, which is tied to their disability assistance. So if they're not on disability assistance, they get the boot. So it's essential to keep them on disability assistance. And how to do that is to create a trust in your will where someone else gets their inheritance to hold in trust for that person that's receiving disability assistance. And that trustee, the person in charge, can pay for that person with a disability's benefit for the rest of their life. And the ministry is totally on board with this. And as long as the trustee doesn't pay more than the prescribed amount per year, the person with a disability will be able to continue on provincial disability assistance with that trust in place. You can provide for a spouse with a trust as well. And this is commonly seen in blended families. So think the Brady Bunch from the 70s. As spouses get together, one spouse brings in children from their previous relationship, another spouse brings in children from their previous relationship, and then it's a scramble to decide what do we do in our will, because we have to provide for all these children and each other. And one of the more common answers is create a spousal trust. So what they do is they take all of their assets in their will and provide them for the spouse, the surviving spouse, to enjoy during their lifetime. And so they can continue to live in the home, they can continue to use the income derived off the investment accounts. And then after their life, it gets kicked back into that original spouse's children. And so it goes back to the children, but is used for the surviving spouse's lifetime. Finally, people pass on vacation property in trusts sometimes. So instead of just giving the vacation property to the 3 children, they create a trust so these 3 children can enjoy it for the foreseeable future in that trust. A lot of consideration has to be planned out in doing that, just because you want them to be able to have a maintenance fund. So if the roof needs replacing, the children aren't tapped out for cash. So oftentimes we do a secondary trust with $50,000 or $100,000 to pay for the new roof and things when they come up. So the children aren't scrambling for cash when these things come up. They just take it out of the trust. So special issues. So just randomly a couple of things that I thought could be helpful to some of our audience members. The most helpful is obviously charitable tax receipts. So we all know that when we give to a charity during our lifetime, CRA, the one nice thing they do is they give us a nice charitable donation receipt. The charity actually does, and the CRA lets us use that to reduce the amount of taxes owing. Similar thing when you donate to charity in your will, the charitable donation tax credit can be used to reduce the amount of taxes owing on your final year of life, or a couple years previous, or a couple years forward. The definite benefit, added benefit, or actually drawback, is that the reason why that's so important, I should say, is because oftentimes the most taxes you'll ever pay is the year of your death. And the reason for that is because CRA has this thing called deemed disposition. And what that means is they imagine that you've sold all your assets the year you die. And so if you have an investment account with capital gains on it, those capital gains are captured and taxed. If you have an investment property or a vacation property with capital gains on it, those capital gains are captured and taxed. If you have an RSP or a RIF, those are entirely brought into the income category of your tax return the year of your death. And so that could amount to huge amounts of taxes. One of the only exceptions to that big tax bill is if you give those assets to a spouse, those assets roll over tax-free to that spouse. And then when that spouse dies, obviously they're taxable at that point. So how you can greatly reduce that tax bill is obviously giving to charities in your will, and those charities will issue you a tax receipt, which you can apply towards those taxes. And that's part of the estate planning methodology as well. So whoever is doing your will should look at your tax burden on death and maybe consider offsetting that tax bill with some charitable donations. If you happen to own foreign real estate, which is real estate outside of BC, Some people consider getting another will to deal only with that real estate. So the will in BC deals with the worldwide assets except for that piece of real estate. And then you have a separate will to just deal with that real estate. And the reason is because if you die with only one will, it needs to be brought through probate in BC, and then your executor hires a lawyer in that other jurisdiction, maybe Florida, let's say, and the Florida lawyer brings the will through probate in Florida courts to be able to deal with that real estate. And so that's time consuming and expensive. And so the way you get around that is to have a will just dealing with that Florida real estate so that both wills simultaneously can go through probate, instead of having a lawyer do it at a much more of a price. Finally, alter ego joint partner trusts. These are something to consider if your estate is over, say, $2 million, and you're over 65 and you're a Canadian citizen. This is a way to avoid probate fee. And so when you have an alter ego or joint partner trust, you actually transfer your assets into these trusts during your lifetime so that very little assets, very few assets are going through your will. And as I said before, the probate fee is only on assets going through your will. So it's not applicable to assets going through this trust. And so just to give you an idea of the cost savings, probate fee on $1 million estate is $14,000. So 2 million, we get into 28,000. You can see the cost savings by doing these trusts as your estate rises in value. So incapacity planning. Basic 2 questions to ask yourself. If you become incapacitated, who will look after your finances? Number 1. And if you become incapacitated, who will look after your health care and your personal care as well? So quick poll, Sarah. Who has a power of attorney?
There we go. It should be popping up on your screen. A couple more seconds here for people to lock in their votes.
And the survey says?
The survey says 48% yes, 43% no, 9% not sure.
Okay, so a little better on that one. So a power of attorney lets someone else manage your finances. And so it's super important because if you don't have a power of attorney and anything happens to you incapacity-wise, so you get incapacitated, no one inherently has the right to manage your finances. And so your finances are pretty much locked. You can't, nobody else can mortgage a home for you. Nobody else can sell a home for you. Even if it's in 2 names, both signatures have to be on that document. Nobody can withdraw from your tax-free savings account, from your life insurance policy, from your RSP or RIF to pay for your care. So a power of attorney is super important to have. And what it does is simply allow someone else to make those financial decisions for you. So everything as big as selling or mortgaging a piece of real estate to small things like just paying a bill out of your account. There's 2 types of powers of attorney. The most common is called enduring, and that just has effect the moment you sign it and ceases to have effect when you cancel it or die. So it's always in effect. The other type is called springing. And well, there's more types of powers of attorney, but these 2 types are the most common for estate planning purposes. So a springing power of attorney is sort of a dormant agreement when you sign it. So it's just sleeping until a doctor or 2 doctors declares you incapable, and then it just springs to life, and then the person can manage your finances from there. The reason why most people pick the first type, the enduring type, is just because you name people who you trust in a power of attorney. And so if you trust them 100%, why make them go through the hoops, jump through the hoops of getting you seen by a doctor, having the doctor sign legal documents saying you're incapacitated? Because that takes 1 or 2 months to organize, and it's just an added burden on them when they're already burdened by other things. So crucially, a power of attorney can be completely customized, so it doesn't have to say one or the other thing. Quick poll question again. Who has a representation agreement?
There we go. And we have 28% yes, 52% no, and 20% not sure.
Okay, perfect. So a representation agreement is sort of like a power of attorney, but it's for healthcare. And the good thing about healthcare agreements in BC is that there is default law on healthcare. And so the default law says that your next of kin can make most healthcare decisions for you. Despite that default law, the slide isn't advancing, but I keep clicking and yeah, there you are. So despite that default law, a lot of people want a representation agreement for 2 reasons. First of all, if you have 3 children and you don't want all 3 of them being a committee deciding what your next healthcare decision will be, say your daughter is a doctor and you prefer her to make the decision over your other children, representation agreement can let you specify that. Number 1, 2, 3, or number 1 and 2 together, and then 3rd if they're both unwilling or unable, sort of thing. The second reason why people want a representation agreement is that you can specify your end of life wishes in it. And so these are statements like, if there's no reasonable probability of my recovery from a extreme illness and my death is otherwise imminent, I don't want to be kept alive by artificial means or heroic measures. That sort of language can be put in a representation agreement. So I've just included this slide just in case you've heard of living wills. Most people have, and advanced directives. So a living will is what we put in a representation agreement right within the body of a representation agreement. So it's not called a living will per se, but it has all the same language. But living wills and advanced directives are freestanding documents, and they're open letters to everyone, care providers, family members, anyone who's looking at it, that says your end of life wishes. And so living wills were the norm in BC and worldwide, actually. Most jurisdictions have the equivalent of a living will called a living will. But in BC, they're non-legally binding. And so the government thought that that was a problem. And so in 2011, they created these things called advanced directives. Basically the same thing, but advanced directives are legally binding, living wills aren't legally binding. So after all your assets are distributed by your executor, your estate's shut down, all the money is long gone and spent, what's there left of your legacy? And so this is sometimes the most important document of all, and it's done by you. And so I call this an ethical will, or some people call it a legacy statement. And it's what stays with your loved ones for the rest of their lives, whereas the assets come and go. And so what it is it's an open letter that discusses your values, your favorite memories, your words of wisdom, definition of success, which is hugely important to especially younger generations, and thoughts to share with your loved ones. So again, that's what stays with loved ones far after the assets have been spent, and you know, they unfold that envelope like years after you've passed away, and it's particularly helpful for closure. So to summarize everything, fully rounded estate planning, incapacity planning, and an ethical will is the best way to provide for loved ones in the most cost-effective, quickest, and dispute-free way. And me being a lawyer, I have to just say this. This presentation was for informational purposes only and should not be relied on as legal advice. Consult with proper legal counsel before implementing any of the things that I have talked about. Okay, so that was it for me. Do you have any questions?
Thanks, Mike, so much. That was really informative. I was madly taking notes, and I'm sure many of the people who are attending as well were. I do have a few questions that have come in over the course of the presentation, and then if people have additional questions, please feel free to drop them into the chat and we'll share them with Mike. So the first question that came in towards the beginning of the presentation, you talked about a substantial estate, or if your estate had a substantial value. Can you define that? Like what should people be thinking about when they're thinking about having a substantial estate to deal with?
Yeah, so I think I mentioned that describing whether probate would be needed or not needed. And so there's no defining point when there's no one. I can't say whether your estate will need probate or will not need probate. It's the individual institutions that decide whether they require probate or not. So I'll tell you a couple points, and this could help answer your question. If you own land that's not jointly owned with someone else, probate will be required. If you have a bank account worth over about $25,000 in your own name, and not beneficiary designated, probate may be required. And that's the frustrating one for me, because I've seen bank accounts go to executors without probate worth maybe $100,000. I've seen banks demand probate for bank accounts worth $7,000. And so it's all over the map. And what I tell executors, it's not legal advice, but it works, is just dress in your Sunday best when you're going to the bank. Look like you have all your ducks in a row and just say, I want access to this bank account, and see what they tell you. Because it's up to the individual bank representative that your executor is sitting down with whether to insist on getting probate before they release the account to your executor, or just releasing the account straight to your executor. And finally, if you have a car, ICBC requires probate to transfer that car if your entire estate is worth over $25,000.
Great.
Hopefully that answers that.
Thanks for clarifying that, Mike. The next question was, somebody had brought up the issue of cross-provincial power of attorney. So if you are living in a different province when you make your power of attorney agreement and then you move, can there be some cross jurisdictional issues that people need to think about? Yeah,
I'll just start off not answering that question, but I'll come back to it. Wills made in another province are oftentimes good in BC. So wills, you don't need to necessarily worry. It's a really good idea to have the will checked out by a BC lawyer, just to make sure there's no oddities that the other province requires, but generally wills tend to be okay province to province. Powers of attorney, different story. Each province seems to have their own odd clauses that they put in their powers of attorney. And so the basic advice is go see a lawyer and see if it's valid. Most lawyers would say you need to do a BC power of attorney.
Great. Thank you. The next question that came in was about including relatives who live abroad in wills or estate plans, and if there's any special considerations there.
Yeah, there's a lot of special considerations. well, I'll first start by saying oftentimes it's in, like, you can't get around it. You're not going to disinherit your son because he lives in New York. So oftentimes I talk about the difficulties with my clients, and they say just that. I'm going to leave them half, regardless of the tax implications or whatever. Each country has their own tax regime, of course. So if you leave it to a US citizen, US resident, they could be taxed on the inheritance according to US tax law. Same with every other country in the world. So that's the major thing, the tax laws. And with real estate, if you're giving real estate to a foreign resident, of course, we have the foreign buyer's tax in BC. And so they'll get dinged a lot. And when I've seen that happen, they choose to sell the home just because it's not worth it financially for them to remit 25% to the government to keep this home.
Thanks, Mike. I'm sure as people move and travel and live in different places more, that's becoming a bigger and bigger issue for people when they make their estate plans.
Yeah, and just as a side note, people ask me foreign executors as well. And there's problems with foreign executors, tax-wise and just convenience-wise. I mean, like if they're living in Australia, that's opposite time zones as us. So if they're trying to hire a real estate agent, a lawyer, accountant, they'll have problems with that. If they're trying to clear out a home, they probably have to come visit. And so it's a real issue, but also tax-wise, they'll have problems as well.
Great. Two different questions on joint tenancy. One was about whether a person can be specified as a joint tenant in your home if they're not your spouse or living on that home, but it's a shared property. And then the second question was about ensuring that the wishes for the house are observed when the house is disposed. So if you can write specific clauses or things like that in your plans.
Yeah. And so the first question, so I'll start with when you own an asset and it gains in value, whether it be a stock portfolio or say a vacation home, that gain in value is called a capital gain. And when you sell that asset or die, that capital gain is taxable. And so bring that to your question. When you own a house and you're living in it, there's an exemption to that tax called the principal residence exemption. So when you sell or die, you don't pay taxes on your home because you've lived in it the entire time you've owned it. Specifically to your question, you own part of your home, but you live there. Someone else that doesn't live there owns part of your home. Their part is going to be taxable. And with the rise in value of homes in BC, we all know that that could be a huge capital gain. And so there's a lot of considerations to be thought of, and using trusts to get around that can be possible, but essentially it's a really bad idea unless you get proper, like, thorough planning advice, because that half of the home or whatever percentage that person that doesn't live there is taxable, and you own your home tax-free, your percentage. So the second question, the second part of that question, remind me again, sorry.
Yeah, it was for joint tenancy, how do you ensure that your wishes are observed when the house is disposed of?
Yeah, so in the will, there's two types of wishes. There's binding wishes and there's non-binding wishes. So lawyers can write both binding wishes and non-binding wishes. Binding wishes, if you want your house to be lived in for 5 years and then sold and then divvied up between X, Y, and Z, it's best to put that in a binding wish, which is in the form of a trust in your will. And might not always be tax efficient, but it achieves what you want. at the end, which is exactly, you can specify exactly what you want done, and your executor trustee has a legal obligation to carry out those terms, and if they don't, then the beneficiaries can sue them. So that's real implications if they don't follow your wishes. The other type of wish is a non-binding wish, and it's just a mere hope that they do these things, and it's just what it sounds like. So you're just hoping, you say, you know, it's morally binding. You're up there in heaven or wherever you are looking down at them with daggers if they're not going to do it, but they can always not fulfill your wishes. And for the beneficiaries at the end of the day, too bad, so sad, because that's not a binding trust put on those people. It's just you gave that property to so-and-so with the wish that they did this, but if they don't do this, the beneficiaries have no claim against them.
And Mike, is it up to the executor to determine whether those non-binding wishes are followed?
No, it's either a trust or it's either a direction to your executor, which is legally binding, or it's specifically said, it's my non-binding wish, or it's my wish, or it's my hope. That's how we word it, at least. Yeah.
Thanks for clarifying that. And then there's one last question. So if there are any further questions, if you can drop them in the chat, we'll have time for maybe one or two more, and then we'll wrap up. And thank you again, Mike. Is there a trust that is similar to a spousal trust, but rather than go to children after the spouse it passes, it goes to nieces and nephews or other beneficiaries?
Oh, so, yeah, absolutely, yeah. So you can have any type of trust going to anyone. So it doesn't have to be a spouse who benefits from the property. It doesn't have to go to a certain class of people after. So in a spousal trust, it's always for the benefit of the spouse, and that benefits from a lot of tax benefits. If it doesn't go to a spouse in your trust for their lifetime, it's not a qualified spousal trust, and so it doesn't have those same tax benefits. But in both cases, you can give the remainder after the spouse dies or after that person dies to whoever you want. Doesn't matter. I was just using the Brady Bunch scenario just to make it clear that that is used in blended families a lot. So they can, yeah, after the spouse dies, I've written wills where everything goes to charity, because if they don't have children, for instance, and have no other close family, then that's the typical case. Everything goes to charity. They just want to make sure their own spouse is cared for during their lifetime.
Great. And I'm going to take one last question because it's near and dear to my heart and the hearts of all of us at the CPAWS team. Can you talk a little bit about donating securities to a charity and how that can be a benefit?
Great question, Sarah. So I mentioned tax-wise, it's a good idea to give, especially because of that huge tax hit at the end of your life, it's a good idea to give a charitable donation in your will, because that offsets the tax. To superpower that charitable donation, if you give shares of a Canadian publicly traded stock that has a capital gain on it, instead of your executor selling that share, paying those capital gains taxes, and giving the charity after-tax money, it benefits your estate from just giving the charity that stock in kind. And that means that they don't have to pay the tax on that, because you've given that stock in kind to the charity, and you get the full tax credit for that charitable donation.
Great.
Yeah.
Thanks,
So
Mike.
that's a great way of supercharging your donations.
Thanks. And I will say that I think that most charities in Canada now are well equipped to handle donations of securities, or at least most of the larger charities. So if you have questions about that, you can reach out to me at CPAWS, or if there's another organization that's near and dear to your heart, if you give them a call or send them an email, there's almost certainly someone on their team there who can direct you to the right form, or or help you kind of get started on the paperwork that your financial planner can manage for you. There are some additional questions about finding an estate planner or finding someone to help them with their estate plans. I see you've got your website up on the bottom of the screen here, westcoastwills.com. I can also share with people in attendance an email address so that you can reach out to someone at Mike's office, but Mike might have a better way for you to get in touch to ask more questions.
Yeah, we have 4 estate planning lawyers here who only do estate planning and probate. So, and I don't want to toot my own horn. This is a informational presentation, so any number of lawyers do estate planning as well. Just make sure that you look at their website, and estate planning is their main thing. A lot of people say on their website, we specialize in estate planning, but when you look at the individual lawyer profile, they say they specialize in personal injury, family law, estate planning, you know, like criminal litigation. So that's not really specialization, but there's a whole bunch of qualified estate planners in Vancouver. And as long as you're going with someone who does this for a living, you can't go wrong.
Great. And just a note from someone who mentioned that if you work with a financial planner, they might also be able to recommend someone who has the right expertise to at least get you started. So
For
that
sure.
might also be a place to start. Thank you so much, Mike. We are so grateful for your time and expertise and sharing them with us. And thank you to everyone who joined in. We're so grateful that you were able to join us as well. As I mentioned, we'll be in touch in the next couple of days with links to the recording, we hope, and also some additional information for you if we can provide some information and some background on some of these questions and the answers Mike provided. And again, thank you so much. So glad to have you with us. Thanks for spending your Wednesday evening with us.
Thanks, Sarah.
Thanks, everyone. Bye-bye.
Bye.